Good afternoon, sir. Very warm welcome. I would like my colleague Kriti to greet sir with the planter. Kriti. A brief introduction about sir. Sir has completed his education up to LLB from Saharanpur. He did his LLM and PhD Law from Faculty of Law, Delhi University. He was awarded medals and certificate by Faculty of Law, Delhi University. Initially, he joined services as LCA in Lok Sabha Secretariat, PHA, New Delhi in 1982, and later on, he was selected in Delhi Judicial Services and joined DJS in July 1985 and acted as Sub-Judge, Metropolitan Magistrate, Presiding Officer, Labour Court and Additional Rent Controller. He was promoted in Delhi Higher Judicial Services in the year 2000 and served as Additional Chief Metropolitan Magistrate, Additional Session Judge, Presiding Officer, Labour Court, Additional District Judge, Presiding Officer, Motor Accident Claims Tribunal, Special Judge for Prevention of Corruption Act, the SC/ST Prevention of Atrocities Act, Fast Track Courts for Trial of Sexual Offences. He also worked as Additional Registrar, the Supreme Court of India. He was promoted as the Principal Judge, Family Court on January 2014 and as the District and Session Judge, Delhi on February 2015. He was superannuated on 31st July 16 as the District and Session Judge, District Shahadra, Delhi. He was selected and appointed as Chairman, Permanent Lok Adalat, Delhi on 9 November 2016. He also authored 2 books, namely Law of Prevention of Atrocities on the Scheduled Caste and Scheduled Tribes, which was published in 2001, and Legally Combating Atrocities on the Scheduled Caste and Scheduled Tribes, 2004. Concept Publishing Company by Concept Publishing Company, New Delhi. He has been examiner of University of Delhi, DDA. He has been trained judicial mediator since 2007 and an arbitrator since 2016. He participated and attended so many conferences and workshops at Institute of Criminology and Forensic Sciences, Delhi, National Judicial Academy, Bhopal, National Judicial Academy, Delhi, Vigyan Bhavan, etc. He delivered lectures on law subjects in Delhi Judicial Academy and presently he is supervising the work of law firm Naval and Associate, legal consultant and advocates and appearing in the matter before Delhi High Court and Supreme Court of India. Sir.
Excuse me. Slide कैसे है? Okay. Next.
Yes, sir.
Or back. Okay. Okay, thank you. Bowing before Baba Saheb Dr. B.R. Ambedkar, I may inform you that I have sent this PPT in your mobile phone. It is available with you in your phone. Chhatrapati Savaji Maharaj, Rashtrapati Jyotiba Phule, Savitri Phule, Parihar, E.V. Ramaswamy, Shromani Sant Ravidas and all others who fought for human rights. I greet Honorable Sri Arun Kumar Misra, Chairperson, Dr. Mole and Sri Rajiv Jain members, Sri Sunil Kumar Meena, IPS DIG, and all the dignitaries, police officers present here, ladies and gentlemen. I also pay my homage to Justice Ranganath Misra and all former chairmen, all those who have in one way or other contributed for a strengthening of human rights. I am thankful and grateful to Sri Sunil Kumar Meena, IPS DIG, for inviting me and giving me an opportunity to share my experiences with you on the subject concerning SC and ST. We celebrated 77th Independence Day few days ago. I congratulate all of you not only for serving the public at large, but also getting an opportunity for serving marginalized, neglected and oppressed countrymen. Although numerous problems are faced by them I mean SC and ST, yet the major problems are illiteracy, educational backwardness, unemployment, economic backwardness, inadequate representation in government service, discrimination, prejudices, hate, biasness, social backwardness, political backwardness, many others. Although I have never been formally associated with Human Rights Commission, yet I feel privileged to be present amongst you for one simple reason, that NHRC is endeavoring to achieve a goal of protecting human rights of Indian society, which is very close to my heart. A scheme of my speech: a status of SC and ST, problem of atrocity on SC and ST, efforts made to encounter problems, reasons for commission of atrocities on SC and ST, SC and SC Prevention of Atrocities Act in nutshell, precautions required to be taken for prosecutions of cases of atrocities, role and responsibility of police in protecting rights of SC and ST, and our own role. This is my speech of a scheme of speech. I am told that all of you are additional DCP or Deputy SP, so all the responsibilities are on your shoulders to implement this act. This is a special act, as described by a status of SC and ST at the dawn of independence. At the discrimination, as described by Baba Sahib B.R. Ambedkar, the doors of education were closed for the untouchables. They were not allowed to bear arms. They could not earn enough money or acquire wealth in any manner. Even in the matter of words, they were not allowed free choices. They could not use decent culture, language, but instead they were required to use crude language in order to help identifications. They had to live outside the village and far away from the towns, in caves, on the trees or huts or tents made of tattered clothes. They could not own animals other than pigs, dogs and donkeys. They were not allowed to eat wholesome food, not to wear decent clothes. In certain regions, they were not allowed to put on clothes which went below the kneecap. They could enter the village only during daytime and had to return to their huts before sunset. They were branded as untouchables, unseeable and unapproachable. Present day status of SC industry. Justice Dhananjay Y. Chandrachud CJI, while speaking on the occasion of convocation of O.P. Jindal University, said, country's 75th independence must also be an occasion for critical introspection, since women and many other communities are yet to effectively taste the fruit of democracy. This was published in Hindustan Times, August 8, 2022. Present day status of SC and ST. I am showing some clips. CM के क्षेत्र में विकसित और पास कॉलोनियों में प्लाट और मकान नहीं खरीद सकते दलित SC/ST. Attacked for wedding, दलित वोमेन इनकाउंटर हर ordeal. खौफ से गांव छोड़कर चला गया पूरा परिवार. गुजरात की नहर से पानी भी नहीं ले सकते दलित समुदाय. One in 5 Dalit children in rural Gujarat didn't get polio drops due to untouchability. Dalit youth killed in public for marrying caste Hindu girls. 5 दलित महिलाओं को निवस्त्र कर घुमाया. दलित प्रधान को झंडारोहण से रोका. दलित फेम ओवर फाइन ऑन वुमेन फॉर एंटरिंग कर्नाटका टेम्पल्स. नाराज दलितों ने बदला अपना धर्म. Dalit families forced off land in Telangana. महाराष्ट्र के सातून में मंदिर में प्रवेश करने के कारण मातंग समुदाय के दूल्हे और मां को पीटा। Present day status of SC, I have seen some clippings, and there are some news of IIM, IIT, Indian Institute of Medical Sciences. It is the report of National Commission for SC Industry, in which it has been told that there is discrimination amongst students who study in either All India Institute of Medical Science or Vardhaman College or IIT or IIM. दिस इज अनोदर। बिरयानी बेच रही युवक ने पूछा जाति दलित बताने पर पीटा। फरीदाबाद के नज़दीक दलित के घर जा रही थी बारात, दबंगों ने नहीं जाने दिया रास्ता। अशुद्ध करने पर दलित की हत्या। देश में 45 केंद्रीय विश्वविद्यालय में SC/ST समुदाय के सिर्फ एक कुलपति। दलित मार्च टू हैंड ओवर ब्रास कॉइन्स टू परवेज हाल्टेड। क्वेश्चंस बिफोर अस। We have to introspect ourselves. We have to put ourselves the questions. Are we performing our duties and doing something for upliftment of SC/ST and OBC and other minorities? Are we constantly making effort to liberate ourselves from the problems we are facing each day? Or we are just passing our time ignoring all these problems? Are we trying to become a good citizen worthy to be followed by others? Are we constantly in touch of literature which guides us to know as to what we should do or what we should not do? We are providing any assistance to fellow members to overcome their problems with which we are also encountering? Are we making some concrete efforts to unfetter ourselves from mental slavery? Are we introspecting ourselves each day to know as to where do we stand? How we overcome ourselves from bias, ego, greed, jealousy, caste-based hatred? Preamble of the Indian Constitution we all know, but I would like to read. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thoughts, expression, belief, faith and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individuals and the unity and integrity of the nations, in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. We have to think whether we have achieved this after 77 years. Causes of atrocity on the SC and ST. According to me and according to so many studies conducted so far, there are reasons. Caste system is one of the reason. Endogamy is another reason. Caste hatred, most important reason. Untouchability, another important reason. Religion, cultural backwardness, illiteracy, poverty, economic dependence of or backwardness, ignorance of law, self-assertions by the SC industry, lack of political will. These were the reasons. Efforts made to encounter problem of atrocity on SC/ST. The inclusion of Article 17 in Indian Constitution, it runs as under Article 17, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Efforts made to encounter problems of atrocity and SC/ST. First, removal of caste disability through the Untouchability Offences Act in 1955. This act was enacted. Thereafter, protection of civil rights through the Protection of Civil Rights Act. That original act was amended in 1976. And if thereafter the atrocities continued, so in the year 1987, the Prevention of Atrocity through the SC Industry Prevention of Atrocity, this act was enacted. Reasons for ineffective implementation. Our parliament has enacted 3 laws. Even then, we still face and see newspapers several instances of atrocity. What are the reasons? The reason, according to me, is non-coverage of all possible forms of atrocity. Number 2, facing atrocity but not reporting them to police. You might have encountered these feelings that atrocity are committed, but the victims prefer not to report to the police. There are so many reasons of it. You are all police officers. You are having primary knowledge of this fact.
बट सर पंजाब में ऐसा नहीं है. पंजाब में तो SC और ST एक्ट में तो बहुत ज़्यादा रिपोर्टिंग होती है. थोड़ा सा भी होता है they immediately go to the police and register the case against the.
I am pleased to hear this from your mouth, because the general rule is that atrocity matters are rarely reported. Facing atrocity but not reporting them to police. There are various reasons that victims face the atrocity but prefer not to report it. Failure of police to lodge FIR and supply copy thereof to victims. Even in Delhi, I have encountered several instances where victims go to police and their reports are not recorded, so they approach the court, Metropolitan Magistrate, for recording of FIR under section 156(3) CRPC. Even then their reports are not reported, then they have to prove the case under section 200 CRPC. So there are I am confining with my experience in Delhi. So failure of police to lodge FIR and supply copy thereof to victim, procedural drawback. In that act there was procedural drawback. Initially even the courts, even the high courts were not aware what is the correct procedure. Initially it was seen that matter has to be reported or taken up for hearing at first instance before the judicial magistrate or metropolitan magistrate. But there was some other view that it has to be heard and decided by the special court constituted under the act. There were conflicting of decisions of High Court, and ultimately this act was amended, and Supreme Court there is ruling that no a special act has also power, but simultaneously magistrate has also power to hear. Failure of police and then procedural drawback. I am lack of infrastructure with investigating agency. During my service as judicial magistrate, I have many instances of meeting you people. I mean police officers, and they told me in my chamber that they face infrastructure problems during their working. So you better know whether the infrastructure is sufficient or it is not sufficient. But according to me, more infrastructure is to be provided to the police officers. And next is non-availability of time with police officers. Police officers are given so many works of different natures, and this investigation of SC/ST Act is as last priority. So this is one of the reasons that this act is not implemented effectively. The other reason is sufficient infrastructure with special courts. Special courts are also given so many hours. Cases under other act, though they also hear simultaneously this act, so they find little time. Negative attitude of the court in atrocity cases. It has also been experienced that this is the there is negative attitude of the courts. This case is the last priority. Overburdening of special courts, cumbersome provision, low rate of conviction, and inadequacy of fora. What I made in as told, I did my PhD in this subject, atrocities on the scheduled caste and scheduled tribe. So I made several suggestions in my thesis. Some of the suggestions were that there must be simplification of procedure, establishment of exclusive special court. Before amendment there were special court, and after amendment now there are exclusive special court. Prompt rehabilitation of the victim of atrocity, legal aid to the victims, creation of centralized special enforcement agency, removal of untouchability, inter-caste marriage, expansion of SC/ST and SC literature, issuance of whip. These were the suggestions that if these are adopted, it may be. Another suggestion, widening of definition of atrocity. All are police officers, and I give one instance. If you read section 379 theft. There is a definition, and thereafter illustrations are given 1, 2, 3 A, B, C, D. But here in this act, definitions is not given, only illustrations are given. So everything is not covered, only a specific instances are covered. And if there are so many cases in which it is said that offence was not committed within the public view. If a person of SC/ST is assaulted within a chamber, then it is said that this was not the public view, so the offence is not allowed. Even then, he was beaten considering that he was SC University, but offence is not made up. So there are deficiency in the definition, according to me.
325A is there, sir.
Yeah,
325A is there.
325A.
5A.
325A is there, yeah.
जिसमें ये लिखा हुआ है कि अगर इसमें कहीं अपराध का नहीं है, तो अगर SC/ST के विरुद्ध कोई दूसरा अपराध करता है तो इसमें कवर होगा.
But in my tenure of service, I have not even seen a single instance where it has been covered. I am happy that you know there is a provision, but the question is whether this provision was implemented, whether any stance was covered.
कवर करते हैं, अब तो दर्ज करते हैं.
Very nice, very nice. If it is covered, then it is very nice. Reform suggestions, another one, asking of questions relating to caste. Whenever now we are living in Delhi or metropolitan city or city in rural area, first of all, when one person meets the other, he says, "What is your caste? What is your caste?" It is asked. My question is, what is the necessity of this question? According to me, they put the question to know what is your caste, then accordingly they will treat you. So according to me, there is no necessity of asking caste of anybody. What is the necessity? Employment of children, blockade of service careers, reforms to economic exploitation. I also suggested that economic exploitation should also be made an offence of atrocity. Untouchability as an atrocity. Previously, before amendment, untouchability was not covered under atrocity, but after amendment, illustration has been added, and atrocity has also been added as atrocity. Negligence by public servant, section 4. Concept of atrocity, indignities, humiliation and harassments.
ये भी है ना सर, सेक्शन 4 भी पूरी नहीं है.
Yeah,
अब इसमें SC/ST के अधिकारियों को छोड़ दिया, वो भले ही गलत करो,
yeah.
उनको भी तो शामिल रखना चाहिए था. जो भी गलत करे उसको सजा मिलनी चाहिए, चाहे वो अधिकारी किसी जाति का हो, क्यों छोड़ा उसको. That is also lacuna.
It may be lacuna, but if you think it on different angles, then that will show that in case where there is a reason not to cover or not to do any action, then put the SC/ST officer to investigate this offence, so that if there is there is deficiency, he will SC victim will be SC and officer will be SC, both will be SC. So think it from different angles. In that situations, both SC will be victimized. Economic exploitation, thereafter untouchability as atrocity, negligence by public servant, concept of atrocity, indignities, humiliation and harassment, feasibility of sensitizing the functionary, publicity of provisions of the act. These were reform suggestions. Amendment made in the year 2015. The scheduled caste and scheduled tribe was amended in the year 2005. More than 80% of recommendation made by me. If you go through my thesis, legally combating atrocities on SC and ST, it is available on internet free of cost. You will find that by 85% of my recommendations were adopted in this in new amendment. Creation of new type of offences, section 3(1)(a) to ZC, section 2(1)(a) to 7 and 4. Applicability of the act. Applicability of the act on offence under section IPC, section 2(3) to 6A. Commission of offences only by specified persons. It means
5A यही तो है सर, 6
हाँ हाँ
5A
5A, yeah. Commission of offence made by specified persons. It means this type of offence is committed by SC and ST. Then it is not offence. If offence is committed by SC against ST or by ST against SC, then there is no offence. That will be covered by other provision of penal law, Indian Penal Code, etc. Protection from various kinds of atrocities. The protection in section 3(1)(a)(2) ZC, there were protection, and section 2(1)(2), 7 and 4. Punishment for neglect of duty, section 4. Compensation to the victims or their legal heirs, schedule 1 was also amended. Previously it was enlarged, and compensation was enhanced.
The rule of 2016.
Salient features of the Act. What are the salient features of this SST and Atrocity Act? Creation of special courts and exclusive special courts, section 14. Previously there were special courts, now exclusive special courts have also been added. Appointment of a special public prosecutor and exclusive special public prosecutor. Before amendment there were special prosecutor, after amendment also exclusive special prosecutor. In externment of potential offender, section 11 and 10 and 11. Attachment and forfeiture of property of accused. In fact, all of you are police officer. I want to know how many of you ever handled or investigated the offence under SC and ST Act. Please raise your hand. Only one officer. Only one officer out of you have investigated. There.
Sir, what is the question, sir? Please repeat, sir.
My question is, how many of you investigated any case under SC and ST Act?
और ये सभी ने किया.
Very, very nice. My another question is, how many of you have ever attached or forfeit the property of the accused? How many of you have taken an action for attachment of property of the accused? Nil. How many of you have taken any action for cancellation of arm license of the offender? Only one. They,
Attachment of property is difficult. He is absconding. On the time he will do that attachment property. Attach the property up. He is not arrested on that time.
I am citing one example. When any case of bribe is reported and trap is laid and anything is found or evidence is made, then not only
That is a DA case.
yeah, DA case.
That is
D-
freelance
uh,
use.
uh,
We are not doing.
on that line, there is a special provision here for attachment. If influential persons or well-to-do persons are committing atrocity on the SC and ST, and that persons have bank balance, etc., why there is why their property has not been attached, so that they may be restrained from using their money power for against the SC and ST. There is provision, attachment of property, and after conviction, forfeiture of property.
We know in case of absconding or proclamation, we do
No, that is it can be even at the time of
That is difference, madam.
their property can be attached simultaneously, instantly. If any offence is reported against them, their property can be attached. So their property can be attached. But my question is, how many of the police officers do this duty? Power of the state government to impose collective fines under Untouchability Act, under Protection of Civil Rights Act, and now under the SCSH Act. There are provisions for imposing collective fines. I want to know how many of you have taken or initiated action, any proceedings for imposing collective fines, because sometimes it is not known who committed atrocity on the person, But it is not that these locality persons have have committed atrocity on these persons, but if police officers are not able to find out who is the actual culprit, then in that situation there is provision for collective fines, imposing of collective fines. So how many of you have taken have initiated action against this, use this provision? Protection from various kind of atrocity. This act provides protection from social disabilities. If you will see, there are some illustrations or collages which provides protection from social disability. I will explain subsequently in my next clippings. Protection from personal atrocity, protection from atrocity affecting properties, protection from malicious prosecution, protection from political disabilities, protection from economic exploitation, protection from blockade in service career. This is social. Protection from denial of access to certain place and use of customary places, section 3.1.6. This is the example. I will not read this provision, otherwise I will not be able to cover my lecture within half an hour. Protection against fouling of water, this is section 3.1 and Y. Protection from atrocity affecting body, protection from atrocity affecting reputation, body. Protection against forceful drinking or eating of inedible or obnoxious substance, section 3.1A. Protection against stripping, section 3.1E. Protection against outrage of modesty, section 3.1WI. Protection against sexual exploitation, section 3.1W second. Protection against injury or annoyance, section 3.1C. Protection against insult and protection against humiliation. Insult by dumping obnoxious substance, section 3.1B. Insult by naked parading. Insult by painting face or body, section 3.1E. Insult by any other similar act which is derogatory to human dignity. Protection against atrocity affecting properties, affecting land, section 3.1G. Have either of you have dealt with any case affecting land, atrocity affecting land? No, not yet. Affecting residential premises. I have shown the clippings when it has been shown that they have not been able to reside in their locality peacefully, and other peoples are forcing them to leave the places. Have either of you acting or investigated any such case? No. Affecting residential premises, affecting existence of property. Against wrongful occupation of land, against dispossession from land or premises of water, section 3.1G. Causing damage to property, section 3.2. Causing destruction of property, section 3.2.5. Protection against atrocity by litigation. The protection against atrocity by public servant on false information. Protection against atrocity by public servant on false information. Have any of you dealt this class? Any of you have investigated any case under this class? Protection against atrocity by public servant on false information. All of us know that there is provision of reservation. 15% is reserved for SC, 7.5% is reserved for ST, and there is roster system. All of you know. Initially it was 13-point roster system, thereafter it was 40-point roster system, thereafter now it presently 200-point roster system. I understand that all of you know the relevance of roster systems. If not, please raise your hand so that I may explain. In one case, atrocity was committed on the member of SC by changing the roster system, by manipulating the roster system. He was a professor in Hindi department. He was acting on an ad hoc basis, serving as on ad hoc basis. When he was appointed, his roster point was such that he was entitled to be appointed. But after when a new principal came, he was not happy with this professor of SC. So he started harassing. He made several complaints against the principals, and principals what he manipulated, he changed the department. There was a business economics. He removed that, and instead he introduced a subject, management studies. So when business roster is manipulated or constructed according to alphabetically, when B is removed from the list and at M it was inserted, then all the roster system disturbed. That resulted into removal of his service. So there are also such cases where when and he got it approved from Delhi University. So though he made a complaint against this provision that the principal manipulated and altered the roster system and give false information to the Delhi University. So action may be taken. Because there are several instances and several illustration classes added here. We have not still so many cases under these classes. It is a new law, so time will take. Protection against atrocity by court on false evidence.
वो जो प्रॉपर्टी सीज था वो हर अक्यूज्ड का कर सकते हैं, कोई
या
अक्यूज्ड उसका
कोई भी एक्यूज्ड का
जिसने अपराध किया
उसकी प्रॉपर्टी
अटैच कर सकते हैं
अटैच कर सकते हैं
या शेल अटैच
नहीं अटैच कर सकते
We
हैं.
are giving given the what why purpose we are given to the court for attachments.
Yeah.
It's a mandatory.
Yeah.
The court will be accepted or not?
No,
Rejected. They are doing like that, sir, in our state. Some cases, they are not doing attachments.
Then the police officer have performed his duty.
Yes, sir.
Then we are satisfied. Our conscience is clear that we have taken, we have done our duty to the best possible under the law. And if other counterpart is not performing his duty, then it is his responsibility, not ours. Our duty was to file application for attachment, and it was, if it was not accepted, then what can we do? Protection against atrocity by court on false evidence. Have either of you encountered any situation where SC/ST people were convicted because of false evidence adduced against them, and they were got convicted in murder case or another case? Have any of you encountered such situation till now? Not now. This class has not been. Is rarely there is any case. When the intention was to get convicted of an offence with capital punishment, section 321I. When the intention was to get convicted of an offence with severe punishment, section 32I. Parliament has enacted law. Parliament, by enacting law, cast duty on us to use the provisions. Now it is our duty to implement it. Protection against atrocity by destruction of evidence by atrocity. You have oftenly used this the clause. Often protection against atrocity by destruction of evidence. Protection against political disability. Not to vote. New amendment according not to vote to a particular candidate, vote in a manner other than provided by law. Not to vote or withdraw nomination. Not to oppose. Not to propose or second nominations. This is also been added in the Atrocity Act. Compelled to eat or drink edible on obnoxious substance. class 1. I will not read. I will read only headings. Dump excreta, waste matter, carcasses or noxious substance in the neighborhood. Garland with footwear or paraded naked or semi-naked. Removing pillows, forcing tonsuring of head, removing moustaches, painting face or body. Wrongfully occupy or cultivates any land. I am not reading because these are the provisions of SC/ST section 3, clause 1, 2, 3, so and so. I am skipping. To dispose or carry human or animal carcasses or to dig graves. Manual scavenging, class J. Performs or promotes dedicating as Devidasis, class K. Cast a vote, file nomination, propose or second nomination in election, class L. Obstruction from performing their normal duties and functions, class M. After elections, propose social or economic boycott, class N. In initial act, there was no clause of boycott. This has been inserted in after amendment. Commits any offence after elections with regard to vote, clause O. Malicious prosecutions, clause P. False or frivolous informations to any public servant, clause Q. Intentionally insult or intimidates within public view, clause R. Abuse in caste name in any place within public view, clause S. Destroy, damages or defiles any object generally known to be held sacred in the high esteem, clause T. This clause is oftenly used because we see instances in newspaper regarding destructions of so many damage statues of Baba Sahib and other persons of high esteem. Meaning of object. For the purpose of this class, the expression object means and includes a statue, photographed and portrait. Promotes of or attempts to promote feelings of enmity, hatred or ill will, class 1U. Disrespect any late persons held in high esteem, class V. Outrage of modesty by touch of sexual nature, class W. Outrage of modesty by gestures, class W second. Corrupts or foul water, class X 1X. Denial of customary right to passage to be place of public resort, class Y. Forces to leave his house, village or other place of residence, class Z. Prevents using common property resources, class ZA, capital A. Prevents entering any place of worship, class ZA, C. Obstruct in practicing any professions or carry on any occupation, etc., class ZA. Physical harm or mental agony on allegations of practicing witchcraft or being a witch, class ZB. Imposes or threatens a social or economic boycott, class ZC. Gives or fabricates false evidence to secure capital punishment, section 2(1). Gives or fabricates false evidence with intent to secure sentence of 7 years, class 2(2). Mischief by fire on an explosive substance, class 2(3). Enhanced punishment for offence having punishment of 10 years more, section 5(2)(5). Destruction of evidence by commission of atrocity, section 2(6). Punishment on public servant on neglect of duty, section 4(1). Role and responsibility of police officers in protecting rights of SC industry. In fact, my lecture starts now. Previously it was a background. The duties of public servant referred to in section 1 shall include: A. To read out to an informant the information given orally and reduce writing by the officer in charge of police station before making any signature of the informant. These are the provisions of either section 156 or section 5 of the rules. So I am not reading in detail.
सर इसका PDF मिल सकता है?
है I have already supplied you. By WhatsApp I have circulated all these to all of you. At 12 p.m. today, I handed over it to the concerned person and asked that he or she is having your telephone number. Please circulate it by WhatsApp or email immediately. So I was thinking that it is in your mobile just now. It is available. Cognizance by a special court. The cognizance in respect of any dereliction of duty referred to in subsection 2 of a public servant shall be taken by special court, special court, and shall give directions to panel proceeding against the public. Enhanced punishment for subsequent convictions. Section 5. Forfeiture of property and used for the commission of offence. This was we had discussed it. Section 7, forfeiture of property certain person. When a person has been convicted of an offence punishable under this chapter, the special court may, in addition to awarding any punishment, by order in writing, declare that property, immovable or immovable, or both, belonging to persons which has been used for commission of justice shall be forfeited to the government. That is section forfeiture. That your is for attachment. Yeah, that is court. ये है after conviction. Your role is before conviction, according to as per the rules. Presumption as to offences. What are the presumption? I will not read it in detail. Presumption offences and other. If a group of persons committed an offence under this chapter and it is proved that the offence committed by a sequel of an existing dispute regarding land of one person, it shall be presumed that the offence was committed in furtherance of common intention or in prosecution of common object. Let me read it first also. The accused rendered any financial assistance in relation to the offence committed by a person accused of or reasonably suspected of committing an offence under this chapter, the special court shall presume, unless the contrary is proved, that such person had abetted the offence. 3C. Section C. For accused was having personal knowledge of the victim or his family, the court shall presume that the accused was aware of the caste or tribal identity of the victim, unless the contrary is proved. There are so many acquittals on this ground that victims has not stated that he is a person belonging to scheduled caste and other is a person belonging to non-scheduled caste. Presumption has been inserted because if suppose both the persons accused and victims are neighbor or resident of the same village, they know caste identity of each other, then there is no necessity of saying that I belong to scheduled caste, or if this has not been done, then it will be presumed that he has committed the offence because he belongs to scheduled caste. Precautions requiring contesting cases of atrocity offences under the SC Industry Prevention of Atrocities Act. It is generally debated that the members of the scheduled caste and scheduled tribe falsely lodged FIR or filed false complaint in the courts. The basis of that claim by the person of non-SC is that most of the cases of atrocity offences ended in acquittal in past. There are so many reasons of acquittal of cases of atrocity. The complaints to avoid acquittal and to ensure conviction must take following precautions in pursuing their cases. Number 1. Law is well set. Avoid delay in reporting the offences of atrocity. If delay, explain it. All of you know that delay is fatal to the prosecution. So, law is well settled that mere delay in lodging the FIR cannot be ground by itself by throwing away the entire prosecution case. The court has to seek an explanation for delay and check the truthfulness of the version put forward. If the court is satisfied that such explanations, then the delay factor cannot be counted against the prosecution. So, delay has to be explained. Preserve victim till medical examination. The complainant or the victim of atrocity has to take precautions with regard to the examination of injured victims of atrocity by a doctor, preferably by a government hospital, unless and until injured or victim is examined and medical legal report is not prepared by the doctor. The injured or the victim should be preserved in the same conditions. The MLC will be helpful in non-proving the case of atrocity. Sometimes, due to variety of reasons, minor injuries are omitted in the medical legal report. These omissions become the case for contradictions between the oral and medical evidence in the court and provides benefit of doubt to the accused. If such discrepancies are noticed, these should be brought to the notice of the doctor who prepared MLC, the investigation officer and the court at the earliest. You are a police officer, you have encountered such cases where this was held that there were contradictions between oral and medical evidence. So, benefit of doubt is usually given. Insist investigation by a special police officer. Section Rule 7 of the SC/ST rules provides that that investigation has to be conducted by a police officer not below the rank of deputy SP. So, if investigation is conducted by any other officer below that level, then that is not acceptable, and on that grounds there are so many acquittals. I have quoted section Rule 7, investigating officer. So, there is no need to read it. I suppose that all of you have read it. Obtain sanction for prosecution offence is a public. Obtain sanction for prosecution if offender is a public servant. Section 197 CRPC comes into play, and if the offender is a government servant, then sanction has to be obtained. Mention all material facts covering all ingredients of offences. Sometimes victim of atrocity or the complaint does not mean all the relevant facts in the complaint so as to constitute offence of atrocity. For example, in case of so and so, the accused challenged the FIR, lodged the complainant on the ground that facts mentioned in the FIR did not disclose commission of an offence under the Act. The court observed that though the complainant disclosed various accusations and abuses having been made by the accused in the name of the scheduled castes, scheduled tribes and addressed to the complainant, yet complainant nowhere disclosed that these accusations and abuses to the complainant were made in the place within public view. As a result, FIR under the Act was quashed. Therefore, care must be taken by the victim or the complainant to mention all the material and necessary facts which constitute an offence of atrocity. Claim compensation. You are police officer, you may advise the victims to claim compensation as per Schedule 1. Apply for cancellation of arm license. I was referring this, discussing this provision. The victim or the complainant of offence of atrocity should also apply for cancellation of arm license of accused of offence and others as per provisions of Rule 3(1)(3) of the rules. If the victims or complainant has apprehension about commission of offence of atrocity against them. I have quoted this rule. It is in this I need to read it. It is with you. Apply for grant of arm license. Have any of you asked any person of SC/ST to apply arm license? My question before you is whether any of you as an investigating officer asked or advised any victim that you need arm license, apply it.
Sir,
No? You applied, you invoke this provision. Very nice. I hope that in case of improper cases, this rule will be applied and put into action. Apply for attachment of property of accused and forfeiture of property of the convict. We have already discussed it, so you should take action under this Act. Support oral evidence by medical or documentary evidence. The next presumption which complainant must take is that should support its oral evidence by documentary and medical evidence, it is necessary not only to allege all the material facts which constitute an offence of atrocity, but it is also necessary to provide the ingredients of the offence. If it is not done, then the accused get benefit of doubt and he is acquitted. The conclusion of the discussion is that victim or the complainant must support his or her evidence by medical and documentary evidence. Prove all ingredients of the offence alleged. The last precautions which the victims of the complainant should take is that he or she must prove all the ingredients of the offence alleged. Failing to do so may result in his or her case into acquittal of the accused. The conclusion of the above discussion is that victim or complainant has not only to allege all the necessary facts which constitute the offence of the atrocity, but also he has to prove all the ingredients of the offence of atrocity by adducing evidence duly supported by the medical and documentary evidence whenever required. Avail advocate of your own choice. Rule 4, 5 and 6 provide that victim has choice of advocate. Never misuse provisions of the act and the rules. This is advice to the people of SC industry. The act has been enacted and the rules have been framed to save the person of SC industry from the atrocity. Therefore, provisions of the act and the rules should be used in genuine cases. The complainant or the victim or the must see that all necessary ingredients are there in the fact constituting the offence of atrocity, and only then he should report the matter to the police. The provisions of the act and the rules must not be misused for taking vengeance to set the personal score. This will not only save the people of SC industry from harassment of unnecessary litigation, loss of their time and energy, but also will help in maintaining good and peaceful atmosphere in the society, which in turn will help our nation to make further progress. Role and responsibility of police officers. Prevention, your role is here, prevention of atrocity by taking appropriate steps if there is apprehension of commission of atrocity, making effective investigation with a specified period and filing the charge sheet in time, effective monitoring of prosecutions and adducing of sufficient evidence before the court, taking appropriate steps to safeguard the victims from fear, inducement, threat, pressure, etc. Suggestions. Illiteracy, which one of backward, has to be eradicated by a spread of education, because education plays an important role. Within 5-10 minutes I will finish it. Suggestion 1 is that we must do our best to encourage, to motivate the public at large to get education. Suggestion number 2. Make your conscience clear by neutralizing yourself from demerits such as bias, ego, jealousy, revenge, hatred, including caste-based hatred. If we ourselves suffer from biasness or caste-based hatred, then we will not be able to do any act under this act. So we have to improve ourselves, our personality, and make ourselves neutralize. Suggestion number, because if there is a bias and caste hatred within us, we cannot perform our duty impartially, as these prohibits us to perform our duty. Suggestion number 3. Remove endogamy as its main cause of caste system. Endogamy means marriage within caste only, not outside the caste. This is called endogamy. So do not encourage endogamy, because caste system is the main hurdle in our progress. This is the view of many thinkers, social reformers and philosophers. Suggestion number 4. Do all other work consciously with complete understanding as what you are doing and what will be its effect on you and nation. Suggestion number 5. Always observe etiquettes and polite and soft in speaking with victims of atrocity and motivate your subordinate accordingly. Suggestion number 6. Acquire knowledge and impart knowledge. पढ़ो और पढ़ाओ, सीखो और सिखाओ. This is because this will help in eradicating ignorance. Suggestion number 7. Be mindful and sensible not only about your rights but also your duty. Police officers of my dream. Every police officer must be awakened, brave, cooperative, compensate, energetic, disciplined, efficient, friendly, intelligent, punctual, non-egoistic, sincere, soft spoken. My plan of these classes to launch a large and publish it monthly, giving all the details of cases decided by the Supreme Court of India and High Courts, latest legislation enacting Parliament and the state legislature, the central and state government scheme for the welfare of these classes, analysis of decisions, law and scheme, and to give wide publicity as regards to their merits and demerits through a law journal named as Affirmative Actions Journal by Society of Implementation of Affirmative Action in Combating of Vice Crime. Thanks for hearing patiently. Now another query, or if you want to have discussions, we may devote some time.
It's all, sir.
I have retired. I am now 67 years of age.
लगते नहीं
And
लगते नहीं हो वास्तव में।
अच्छा नहीं लगते? 80
67 years।
जी
इतनी एज लगती नहीं है बोल रहे हैं।
हाँ ये बोल रहे हैं. दिस इज़ a compliment for me. I am thankful. Thank you very much. So
आपका नंबर दीजिए आप.
जी लिखिए, सब लीजिए. 99103 9910384 662 662. दूसरा है 8800 जी 9910384 662. सेकेंड हाँ 662. नेक्स्ट नंबर इज 8800 0085 2616. माई ईमेल आप और लिख लीजिए. मेरा नाम Dr.T.R.Naval @yahoo.co.in. Dr.T.R.Naval @yahoo.co.in. Another email is Dr.T.R.Naval हाँ दूसरा है Dr.T.R.Naval @gmail.com. @gmail.com.
लंच लें सर हमारे साथ आप।
जी
लंच लें हमारे साथ।
thank you very much. I am happy to meet all of you, and I hope that in future we will see each other and cooperate with each other.
Yes sir, why not?
Whenever you need my services, I am always available. My office is in GK1, GK Part 1. I am available, so I have no other regular assignment with me. Thank you very much. जी thanks.
Good afternoon all. I, on behalf of police officer present here as trainees and NHRC, would like to give vote of thanks to respected T.R.Naval sir. Sir has enlightened us with various aspects of policing in regard to protection of SC and ST, protection of rights to SC and ST. Sir has also sensitized us on various suggestions to stop atrocities on SCs and STs and various legal provisions associated with it. So I would once again like to thank you, sir, for sharing your vast knowledge with us, which indeed help us, I think, immensely when we go to our respective states for day-to-day policing. Thank you, sir.
Now of the report, I can take your 2 minutes.
Yes, sir.
My request to all of you that do your work at any length of time, but don't be under pressure. Working long hours is not fatal to the health, but working under pressure is fatal. So my advice is you can do your work from morning to evening or in night. That will not cause any ill health or ill effect on your health. But don't take pressure. This is my advice. And be always positive. Thank you.